Sure.
I mean, now that we've decided that former presidents can be prosecuted, this current case before us is the first instance, but I fear it's not going to be the last. Now, let's suppose this ambitious district attorney in an anti-Biden jurisdiction or venue decided to prosecute former President Biden, which I think would be a mistake. But he meaning former President Biden, would have to defend himself, wouldn't he?
Yes.
And suppose he won, he'd still have to pay his lawyer, wouldn't he?
That's true.
Are lawyers cheap?
Only those of us who teach.
No, strike that. I know they're cheap. Are they inexpensive?
No, they're not.
So President Biden could spend millions of dollars.
That's true.
Even if he won.
Yes, sir.
Now, let's suppose after that trial was finished, another ambitious district attorney in another venue or another jurisdiction decided to do the same thing.
What you just watched is a perfect example of why Senator John Kennedy is one of the most effective questioners in Congress today. This wasn't about theatrics. This wasn't about scoring cheap political points. Senator John Kennedy was doing what too many lawmakers avoid: testing logic, exposing consequences, and forcing legal experts to confront reality instead of hiding behind theory. What stood out immediately is how calmly and methodically Senator John Kennedy walked the witness through the implications of this Supreme Court decision. No shouting, no insults, just relentless clarity. And by the end of that exchange, it became painfully obvious why this issue matters far beyond Donald Trump or Joe Biden. If you care about constitutional balance, presidential decision-making, and how power can be abused through the courts, you're going to want to watch this entire breakdown. I'm Audrey, this is Congress Lens, and if you value sharp congressional scrutiny without the spin, make sure to like the video, subscribe to the channel, and turn on notifications so you don't miss what's really happening in Washington. Now let's get into it.
Chairman, thank you for being here. Professor Mascott, this case that we're talking about, Trump v. United States, it was before the United States Supreme Court because the Biden administration decided to criminally prosecute former President Trump. Is that correct?
Yes, Senator.
And in fact, President Biden's lawyer actually asked for expedited review and an expedited decision by the Supreme Court. Is that correct?
Yes, the prosecution would have found expedited review helpful.
When the court handed down its opinion, well, strike that. The title of our hearing is, quote, "When the president does it, that means it's not illegal." And Chairman Durbin explained what he meant by that, but I just want the record to be clear. Did the Supreme Court, in its opinion, ever say, quote, "When the president does it, that means it's not illegal"?
No, that doesn't appear in the opinion.
All right. At the oral argument of this case, President Biden's lawyer actually conceded, did he not, that core functions of a president should have absolute immunity?
Yeah, I do think there's agreement that core functions should have immunity.
In fact, President Biden's lawyer said, quote, "Core functions can't be regulated at all."
That's correct.
Close quote.
Yes.
Okay. What is forum shopping?
Forum shopping is the act of trying to find a court that you think is going to rule favorably to you.
Does it go on in the United States?
Many folks think that it does.
Yeah, it does. It's hard to stop. Let's just stipulate for a moment that America's withdrawal from Afghanistan was not a model of efficiency. People died, including Americans. Can you imagine a scenario with respect to President Biden, now former President Biden. Can you imagine a scenario in which a district attorney in a jurisdiction that repeatedly voted overwhelmingly against President Biden and whose voters did not like President Biden? Can you imagine a scenario in which an ambitious district attorney, after President Biden is out of office, could bring a charge against former President Biden for criminal negligence in the death of Americans? Can you imagine that?
Well, Senator, that would be very troubling, and so that's one of the things.
But can you imagine it happening?
I could imagine district or attorneys wanting to bring such an action, sure.
I mean, now that we've decided that former presidents can be prosecuted, this current case before us is the first instance, but I fear it's not going to be the last. Now, let's suppose this ambitious district attorney in an anti-Biden jurisdiction or venue decided to prosecute former President Biden, which I think would be a mistake. But he meaning former President Biden, would have to defend himself, wouldn't he?
Yes.
And suppose he won, he'd still have to pay his lawyer, wouldn't he?
That's true.
Are lawyers cheap?
Only those of us who teach
No,
law.
strike that. I know they're cheap. Are they inexpensive?
No, they're not.
So President Biden could spend millions of dollars,
That's true.
even if he won.
Yes, sir.
Now, let's suppose after that trial was finished, another ambitious district attorney in another venue or another jurisdiction decided to do the same thing. And then another. And then another. Can you understand what the court was talking about when it said we can't allow the court system to have a chilling effect on a president, any president, in making these decisions? Can you understand that?
Absolutely. The risk of facing that would certainly significantly impact how a president would make decisions in office, and that's the last thing we want.
Can I have 30 more seconds, Mr. Chairman? I don't want to mispronounce your name, sir. Don't count my fumbling around against me. Mr. Lacavara?
Never have.
You were vociferous in your criticism of this opinion that the words presidential immunity don't appear in the Constitution. Is that right?
That's part of it, yes, sir.
Do the words separation of powers appear in the Constitution?
No, I acknowledge that there is a structure called the separation of powers.
Is there any doubt in your mind that we have separation of powers in the United States Constitution?
No, and I think it's important to understand what the separation of powers does and does not imply. And
Right.
what it does not imply, in my judgment, is the kind of immunity that the Supreme Court established here.
Okay. Thank you, Mr. Chairman.
Senator Klobuchar.
Thank you, and thank you to our witnesses. Thank you, Chair Durbin, for holding this important.
After watching this full exchange, it's clear Senator John Kennedy wasn't defending a person. He was defending the office of the presidency and the constitutional system that keeps this country functioning. What Senator John Kennedy did brilliantly here was strip the argument down to its real-world consequences. Instead of debating abstract legal philosophy, he asked a simple but devastating question. What happens next? The legal expert openly acknowledged that President Biden's own lawyer conceded during oral arguments that a president's core constitutional functions cannot be regulated at all. That's not a Republican talking point, that's a fact from the Supreme Court record. And once that concession is made, the argument that presidents can be freely prosecuted for official decisions starts collapsing under its own weight. Senator John Kennedy's hypothetical about President Biden and the Afghanistan withdrawal was especially powerful. Not because it accused President Biden of wrongdoing, but because it exposed the danger of precedent. If one ambitious district attorney in a hostile jurisdiction can criminally charge a former president over policy decisions, then every former president becomes a permanent legal target. The witness admitted this scenario is not only possible, but likely. And that's the chilling effect the Supreme Court warned about. Senator John Kennedy made it crystal clear. Even if a former president is innocent, the punishment becomes the process. Endless prosecutions. Millions in legal fees. Years spent defending decisions made while serving the country. That reality would absolutely affect how any sitting president governs, whether Republican or Democrat. This is where Senator John Kennedy's constitutional argument truly lands. Critics keep saying, presidential immunity isn't written in the Constitution. But Senator John Kennedy shut that down cleanly by pointing out that separation of powers isn't written there either, yet no serious person denies it exists. The witness tried to argue that separation of powers doesn't imply immunity, but what Senator John Kennedy exposed is that without some protection, the executive branch becomes subordinate to prosecutors and courts acting with political motives. That's not accountability, that's weaponization. What made this exchange especially effective is that Senator John Kennedy didn't exaggerate, didn't misquote the court, and didn't claim the Supreme Court said something it didn't. In fact, he went out of his way to clarify that the court never said, when the president does it, it's not illegal. That honesty strengthened his entire argument. This wasn't about defending Donald Trump. This wasn't about attacking Joe Biden. This was about preventing a future where presidents govern in fear instead of leading with conviction. And that's why Senator John Kennedy won this exchange, not with volume, but with logic. At Congress Lens, this is exactly the kind of moment we focus on, when constitutional consequences are laid bare and the political noise falls away. If you want more breakdowns like this, stay locked in right here.